A warm welcome to all of you for another session of corporate law conducted by Onlineàk. Today we are going to discuss about the concept of organizational personality. If you remember, we are still in the first lesson. We have two recordings already. First one was on the incorporation of a company, features of a company, and we moved on to the advantages and the disadvantages of a company. And today we will be discussing about the concept of the corporate whale or about organizational personality. So first itself we are going to discuss about corporate personality or separate legal personality. It's given there. Under company law, subsequent to incorporation, a company becomes a separate legal personality as compared to its members. So what we discuss as corporate personality is the owners are considered to be separate from that of the company. So company has its own separate legal personality from the owners, shareholders, directors and all other persons associated with the company. In other words, the write down company is distinct and different from its members. Company is distinct and different from its members. So this image also here shows the same thing. Company is considered to be separate from its shareholders, owners, directors and whatnot. In the eyes of the law. So in the eyes of the law, company is considered as a separate legal person. Simple example, let's take in a family, parents have children, right? But children are considered as separate persons, separate legal units, separate persons. Same way, here also, though it's the shareholders' money that creates the company, company is considered as a separate legal entity from the shareholders, directors and other associated persons of the organization. It has its own seal and its own name. Those we discussed. Company has its own seal, company has its own name. Its assets and liabilities are separate and distinct from those of the members. Members have their own assets and liabilities. It is capable of owning property, incurring debt, borrowing money, employing people, having bank accounts, entering into contracts, suing and being sued separately. So all of these features of a company we have discussed separately. Company has its own property, company has its own seal, company can sue, company can be sued, and it's a separate unit from its owners and shareholders. After that you can write down sole proprietors and partnerships. Sole proprietors and partnerships. Sole proprietors and partnerships are not separate legal personalities. Are not separate legal personality. So we don't consider sole proprietorships, partnerships as separate legal entities. This separate legal personality is only there for companies. Thus cannot be sued or sue in their own name. That's why I gave this example also to you before. If you are filing a case against a sole proprietorship or a partnership, you have to file the case against its owners, either the sole proprietorship's owner or the partnership's owners, right? But when it comes to a company, you file the case against the company, not the shareholders. We have discussed these before. One of the most important consequences of incorporation is the write down corporate personality. Corporate personality. Corporate personality which a company acquires. So one of the most distinct features of a company as opposed to a sole proprietorship and a partnership is that it's a separate legal unit. This concept establishes the idea that the law recognizes that companies are a legal entity or a person capable of acting independently and its own right. I explained this to you before. I told you that in law there are two types of persons. There are natural persons and legal persons. So, natural persons are people like you and me, born out of a mother and father, made out of flesh and blood. We are natural people. And on the other hand, there are legal entities like companies, which are also considered as separate legal persons under the law. So, when a company becomes incorporated or formed, the law views the company as a legal person which is distinct and different from its shareholders or owners or the directors who run it. So, the company is separate from the owners and its shareholders. A company may sue and be sued in its own name and hold property separately to its shareholders. This separate legal personality has the consequence that a company has a perpetual succession. That's why I told you when it comes to sole proprietorships or partnerships, when the sole proprietor dies or when the partners dies, automatically business will close down. But when it comes to companies, it is not so. Even if one shareholder dies or resigns or something happens, no problem. Company will still be going, which we call as the perpetual succession. Its legal existence survives its shareholders and directors. So, the legal existence survives the shareholders and the directors. Its existence is ended when it is wound up pursuant to the Companies Act. So, only way that a company will come to an end is when the company is particularly wound up. Until winding up, company will be moving on with perpetual succession, irrespective of what happens to its shareholders or directors. So, that is about the corporate legal personality. Very, very important concept for us to understand. So, next we are going to discuss about the instances where the concept of corporate personality is applied. In what situations does this concept that we discussed before, the corporate legal personality situation concept, in what situations does it come into play? Section 2.2 of the Companies Act sets out the capacity and rights of a company. So, according to Section 2, subsection 2 of the Companies Act, Section 2, subsection 2 of the Companies Act sets out the capacity and the rights of a company, what a company can do. A company has the capacity, let's write down, I'll explain, both within and outside Sri Lanka, both within and outside Sri Lanka, both within and outside Sri Lanka, to carry out and undertake any business or activity, to carry out and undertake any business or activity and to undertake or engage in or enter into any transaction subject to the restrictions imposed by its articles of association. Restrictions imposed by its articles of association, right? So, usually according to Section 2, subsection 2 of the Companies Act, it says that a company can both within and outside Sri Lanka carry out and undertake any business activity. A company both inside Sri Lanka and outside Sri Lanka can undertake any business activity, undertake and engage in any transaction. Only a restriction on any transaction or business that a company could do, any restriction will only be mentioned in the Articles of Association. So, the only restriction imposed will be through the Articles of Association of the company. It also has all the rights, powers and privileges necessary to carry out the aforesaid function. So, actually a company will have the powers, duties, rights to do anything any business, any legal business, outside, inside Sri Lanka, to enter into any transaction, only restriction will be through the articles of association of the company. More about the articles of association we will be discussing in the future. So this was said in several cases also. One case example you can write down, Solomon versus Solomon and Corporation Limited. Very, very important case. Even when you are writing answers, we expect that you will know cases of this sort. Solomon versus, this is a UK case, Solomon and Corporation Limited. Solomon versus Solomon and Corporation Limited. Mr. Solomon, a boot manufacturer, converted his business into a limited liability company. So I'll first tell you what happened in this Solomon versus Solomon case, and thereafter we will come to how it is in relevance to the concept of corporate legal personality. It's a very, very important case. So earlier, in Solomon versus Solomon, Mr. Solomon had a sole proprietorship, a boots business. So he was making boots, a boots manufacturer called Mr. Solomon. He had a sole proprietorship and the business was doing really, really, really great. And at one point, Solomon decided to convert his sole proprietorship into a sole proprietorship into a company. He decided to convert his sole proprietorship into a company where the major shareholder will be Mr. Solomon himself and the other shares held by his family members. Major shareholder Mr. Solomon, other shares held by his family members. Now, the company that Mr. Solomon incorporated was not as successful as his sole proprietorship. It was not as successful as his sole proprietorship, and thereby company went on to incur more and more losses. And at one point, Mr. Solomon wanted to dissolve the company, and he dissolved the company, and whatever the monies that was in the company, he was able to pay some of the creditors. Some of the creditors were left unpaid. And these creditors went to court and said, this is very unreasonable. This Mr. Solomon sole proprietorship only he converted into a company. And Mr. Solomon was the major shareholder, majority shareholder of the company as well. And now, because it's a company, he is not paying us the dues from his personal money, he is only paying using the company money, but this is the same sole proprietorship that has converted to a company. So therefore, he should sell even his personal assets and settle the debts of the creditors. But of course, court said, no, that is wrong. Why? Now it's a company. In a company, shareholders have limited liability. Company is considered as a separate legal entity because company has its own corporate existence. So therefore, whatever that you will get is from the funds of the company, right? Company has ultimate liability, or company has the complete liability on all the credits of the company. But other than that, shareholders don't have to sell their personal assets and settle the dues of the company because shareholders only have limited liability. So in this case of Solomon versus Solomon, this was one of the main cases which established this corporate personality, where courts identified that Mr. Solomon and his company, Solomon and Corporation Limited, are two different legal entities. It's given there, Mr. Solomon, a boot manufacturer, converted his business into a limited liability company. His wife, children and he were shareholders. Solomon also took out debentures in his own name. About a year later, the company became insolvent. The assets of the company were just sufficient to pay the debentures and nothing was left to pay the unsecured creditors. The creditors sued against Solomon to recover their amount. So creditors said, look here, this is Mr. Solomon's company itself. So Mr. Solomon has to sell his personal assets even and settle our dues. It was argued on behalf of unsecured creditors that though the company was incorporated, it never had an independent existence. It was Solomon himself trading under another name. House of Lords held, as the company was duly incorporated, it is an independent person with its rights and liabilities. You can highlight there. As the company was duly incorporated, it is an independent person with rights and liabilities. If it's a properly incorporated company, company will have its own rights and liabilities irrelevant or irrespective of Mr. Solomon. Appropriated to itself, thus making Solomon and Corporation Limited liable and not Solomon himself, not the Solomon person. Okay, that was one case, Solomon versus Solomon. So these cases are important if you should get a question on corporate personality, you can use these cases to answer, right? Second case you can write down, again another famous case, Lee versus Lee's Air Farming, Lee versus Lee's Air Farming Limited, Lee versus Lee's Air Farming Limited. So let's see what happened in that case. Lee formed a company in which out of 3,000 shares, he held 2,999, meaning only one share was given to someone else and the last share was held by his lawyer. So Lee was a person, he had a company, 3,000 shares in the company, 2,999 shares were held by Lee. Only one share by his lawyer. He was the governing director of the company and was also employed as the chief pilot of the company. So he was a employee, director, shareholder, majority shareholder as well. When he was killed in a plane crash, his wife sued the company claiming compensation under the Workers' Compensation Act, under which the employer is liable to pay compensation to a worker who suffers an injury during the course of his employment. So what happened was, it was Mr. Lee's company. I mean, he was having 2,999 shares, only one share held by his lawyer. He was the co-pilot of the company as well, the chief pilot, and in an air crash, Mr. Lee passed away. Now, his wife was claiming compensation because he was also an employee of the company, of Lee's Air Farming Limited. So, therefore, wife asked for compensation for the employee status of Mr. Lee under the Workers' Compensation Act. She succeeded in her claim as the Privy Council held that company has a separate, now actually argument of the company, argument of Lee's Air Farming was that, Lee's Air Farming is Lee's. So Mr. Lee, now because Mr. Lee died, Mr. Lee can't claim, compensation as an employee because it's his company. But the Privy Council said, no, that is wrong. When Mr. Lee incorporated Lee's Air Farming Limited, Lee's Air Farming Limited is a separate legal entity and therefore Mr. Lee as an employee can claim compensation under the Workmen Compensation Act. Privy Council held that company has a separate legal personality distinct from Lee and that the company could enter into a contract of employment with Lee and also appoint him governing director or chief pilot. So it's the company. Now, shareholder status of Mr. Lee is one thing and his employee status is another thing. So as an employee that he can claim compensation, right? Because properties of the company don't belong to the shareholders, properties of the company belong to the company. That's the reason, right? So you can write down there after that, properties of the company, do not belong to the owner of the company. Properties of a company do not belong to the owner of the company. So two cases we have discussed here. One was the Solomon's case. And the other one was the Lee's case, and now we are going to study another case here. The third case that we are going to study. Third case you can write down, Makora versus Northern Assurance. Makora versus Northern Assurance. Makora versus Northern Assurance, the dates and all are given, right? So let's see what happened in the Makora case to show that properties of the company do not belong to the shareholders but to the company itself. Mr. Makora owned a timber estate. So Mr. Makora had a timber estate for himself, a big, a sort of like a few acres of timber for him. He sold timber from this estate to Irish Canadian Sawmills Limited, a company in which Mr. Makora was the sole owner with nominees, right? So the timber of Mr. Makora's estate, he sold it to a company called Irish Canadian Sawmills Limited, of which Mr. Makora was the sole owner. He was the complete shareholder, right? With some nominees. He took out insurance policies on the timber against fire with Northern Assurance in his own name and not in the name of the company, right? Then he insured the property, right? He insured his estate, the timber estate, with Northern Assurance, insured it under his name because it was his timber estate. No, he insured it under his name. Due to a fire, Northern Assurance refused to pay because the timber was owned by the company and not by Mr. Makora. Now, particularly what happens is the estate is that of Mr. Makora. He is selling this timber to a company which is solely owned by him. Now the timber is owned by the company because he has sold it, but the insurance is still under the name of Mr. Makora. Can you claim insurance for someone else's property? For example, can you claim insurance for your house? You get an insurance for your house and something happens, you can claim because it's your house. Can you get an insurance for your vehicle? Of course you can. Can you get an insurance for your husband or wife? Of course you can because that is yours. Can you get an insurance for your neighbor's wife or husband? That you can't because that is not yours, right? So you can only make an insurance claim for something that you have ownership in. Now when you take the timber here, the timber was owned by the company. It's correct that Mr. Makora was the sole owner, but still it's the company. And the insurance was taken under Mr. Makora's name. So when the fire destroyed all the timber, company wanted to claim the insurance said no, because the ownership and the ownership and the insurance is in two different names. So therefore Northern Assurance won the case and did not pay Makora for the lost timber due to the fire. Due to a fire, Northern Assurance refused to pay because the timber was owned by the company and not by Mr. Makora. Therefore, because the company was a separate legal entity, it was not bound to pay Mr. Makora any money. Because company was a separate legal entity, they didn't have to pay Mr. Makora. The House of Lords held that the insurers were not liable on the contract since the timber that perished in the fire did not belong to Mr. Makora, in whose name the insurance policy was held. Lord Sumner said it was not his. It belonged to the Irish-Canadian Sawmills Limited. He stood in no legal or equitable relation to the timber at all. Because the timber was owned by the company, not by Mr. Makora, but the insurance was by Mr. Makora. His relation was to the company, not to its goods. So he was the sole shareholder of this Irish-Canadian Sawmills, but can't help it because Irish-Canadian Sawmills is a separate legal personality, is a separate corporate legal person. So that was said in the case of Makora versus Northern Assurance. So three cases that you ought to remember when it comes to corporate personality, organizational personality. First one is the Solomon case, Solomon versus Solomon and Corporation Limited. Then Lee versus Lee's Air Farming Limited. It's a must that you remember these. And Makora versus Northern Assurance. The year of the case, those you don't have to know. Just the names if you know, that is enough. So remember we studied three cases for corporate legal personality. Next we are going to discuss the consequences of corporate personality. What happens because of the corporate personality. Alright, so with that we are going to discuss the consequences. Now we know what is corporate legal personality. Next we are going to discuss the consequences of corporate personality. This is not a new area for you. What we are going to discuss here is the same features of a company that we discussed before. The same features of a company is what the company gets because of its corporate existence, because it is a separate legal person. So first itself, the consequences of corporate personality. First one you can write down. A company has perpetual succession. A company has perpetual succession. A company has perpetual succession. Company has perpetual succession. I told you before, even if anything happens to the shareholders, directors, company will still be surviving because of its separate legal personality. A company continues to exist even in the instance of death, bankruptcy or transfer of ownership interest of a shareholder. Second point you can write down. A company is capable of suing and being sued suing and being sued, suing and being sued, comma, it can take legal action, it can take legal action, it can take legal action to enforce its rights, to enforce its rights, or be sued by others, or be sued by others for liabilities owed to them. Be sued by others for liabilities owed to them. I told you, usually if you are filing a case against a sole proprietorship or a partnership, you have to file the case against the owners, either the owner of a sole proprietorship or the owners of a partnership. But when it comes to companies, you have to file the case against the company name itself. Also, if a company has a problem, company can file a case against any person. You don't have to go by the name of the shareholders, owners or the directors. A company is capable of suing and being sued. It can take legal action to enforce its rights or be sued by others for liabilities owed to them under the company name itself, because the company is a separate legal personality. Third one you can write down. A company can acquire comma, hold and dispose of property a company can acquire, hold and dispose of property. It can do so in its own name, and the shareholders as owners have no proprietary interest in the company's assets. Like we discussed in Mokora versus Southern Assurance case, company has its own properties. Company can own properties in its own name and without any proprietary interest by the shareholders in the company's assets, right? Because the company has a separate legal personality. Next point you can write down. All of these we have discussed before. It can carry out business. It can carry out business, comma, enter into contracts, and be bound by obligations. And be bound by obligations. It can carry out business, enter into contracts and be bound by obligations. We discussed at the beginning of today's lecture itself that a company can do any business that they want. Only restriction is the restrictions put in the articles of association of the company. They can do any business they want, transact in any way they want, enter into any contracts under the company name itself, and they have their own obligations. Next point you can write down. Shareholders' liability is limited. Shareholders' liability is limited. Shareholders' liability is limited to the amount prescribed in the Companies Act, depending on the type of the company. So, company will have unlimited liability on the liabilities of the company or on the credits of the company. Shareholders will only have limited liability according to the amount they have contributed to the company or amount they have invested in the company. Their liability will be limited to that amount. Their liability does not go beyond that. So, shareholders have limited liability. Company has unlimited liability on the affairs of the company, because the company is a separate legal personality. So those are the features that a company gets, or consequences that a company faces because of the corporate personality. So with that, we are coming to the inception of where did this separate legal personality come? With what does this separate legal personality come? We say that it comes with this particular concept called the veil of incorporation. It comes with the concept called the veil of incorporation. So next we are going to discuss the concept of the veil of incorporation. So this diagram shows it very well. This is the veil of incorporation, right? Meaning between the company and the shareholders there is a veil. You can think of it in this way, like a stage play. In a stage play you can see actors, actresses are in front. You can't see the people who are backstage behind the, so there's a, what do you call it, screen, not a screen, maybe like a cloth behind the performers. So behind that only the backstagers. Because of that cloth, you can't see the backstagers. Because of that veil, you can't see the backstagers. Same way, companies like they are on the stage. And the shareholders, owners are backstage and their faces are covered with the veil that is behind the performers. So that is what we call as the corporate veil or the veil of incorporation. The corporate veil or the veil of incorporation is a legal concept that, write down, separates the personality of a company, separates the personality of a company, separates the personality of a company from the personalities of its, from the personalities company, from the personalities of its shareholders, separates the personality of a company from the personalities of its shareholders and protects them from being personally liable for the company's debts and other obligations. So basically, corporate veil separates the personality of a company or a corporation from the personalities of its shareholders, giving the limited liability status to the shareholders, thereby giving the limited liability status to the shareholders. This was established in the landmark judgment that we discussed, landmark judgment of, write down, Solomon versus Solomon Corporation Limited. Solomon versus Solomon Corporation Limited, which held that legal personality of a company is a veil or mask which covers the identity of its shareholders. So the veil of incorporation is a veil or a mask, as I told you, that will cover the faces of the identity of the shareholders. However, it must be noted that this protection is not ironclad or impenetrable. Typically, it's very difficult to penetrate the corporate veil. But is it impossible to penetrate the corporate veil? Of course not. You can penetrate the corporate veil, but usually we like to keep the corporate veil intact because it gives the company its separate legal personality. So therefore, in very rare situations only we will pierce or lift the corporate veil, but it is not ironclad or impenetrable. Of course, in some situations, legally you can penetrate or pierce the corporate veil, where a court determines that a company's business was not conducted in accordance with the provisions of corporate legislation, or that it was justified for illegal activities or fraud, it may hold the shareholders personally liable for the company's obligations under the legal concept of lifting the corporate veil. So corporate veil gives the company a separate legal personality and gives the shareholders their limited liability status. But there can be situations where court will intervene or interfere to lift or to pierce the corporate veil. In situations where there is something illegal happening, hiding behind the context or pretext of a company, in those situations court will intervene to lift the corporate veil or to pierce the corporate veil. So that is what we are going to discuss next, the lifting of the veil of incorporation, lifting of the veil of incorporation. As a general rule, a corporation is distinct from its shareholders. Why? Because corporation have its separate legal personality. The corporate veil is the legal concept that separates a corporation from its shareholders, that induces the courts to look upon a corporation as a separate legal entity or a separate legal personality. While the court should respect the purpose for which the corporate veil exists, that is to separate the corporate body from its shareholders. So why we have the corporate veil is to separate the corporate body from the shareholders. There are instances that the law permits the courts to either lift or pierce through the veil. So there can be situations where, as shown in this picture, courts will, you can see they are the judges, they can look through the corporate veil to see who is hiding behind the pretext or the context of a company. In some compelling situations, you can write down, courts have lifted the veil of incorporation. Courts have lifted the veil of incorporation. Courts have lifted the veil of incorporation and have held that the shareholders may be liable for the acts of the company. So I told you, because of the corporate veil, company gets its separate legal personality. So because of the corporate veil, company gets its separate legal personality and shareholders have limited liability. Meaning, if the corporate veil is lifted, what will happen? Company loses its separate legal personality and shareholders will lose their limited liability. So basically, if I show it like this, because of the corporate veil, right? Because of the corporate veil, now you can see the shareholders here. Shareholders have limited liability. And the company is a separate legal personality. Company is a separate legal personality. So the moment the corporate veil is lifted, company loses its separate legal personality and the shareholders' limited liability becomes unlimited. Shareholders' limited liability becomes unlimited. That is the effect of lifting the veil of incorporation. That's the effect of lifting the veil of incorporation. Right. So now let's see after that. Right. Where a fraudulent and dishonest use is made of the legal entity, the individuals concerned will not be allowed to take shelter behind the corporate personality. In the pretext or context of corporate personality, we can't allow anyone to do something illegal. So if someone is doing something illegal by hiding behind a company, of course the law itself will allow to lift the veil of incorporation to show who is hiding behind a company to do any illegal activities. In such instances, the courts will disregard the corporate personality and look behind the real persons who are controlling the company. Look behind who are the people who are controlling the company. This principle is known as, write down, lifting or piercing through the corporate veil. Lifting or piercing through the corporate veil. However, it must be noted that lifting the veil of incorporation is a rare exception to the rule. As I told you, all the time courts will not allow to lift the veil of incorporation, then there is no purpose of the veil of incorporation. separate legal personality of the company or the limited liability of the shareholders. So therefore, only in very limited situations that court will allow to lift the veil of incorporation. Limited liability is a paramount principle in business law, and undue inference of this rule may cause severe unpredictability. So if you allow to lift the corporate veil as and when something goes wrong, then there is a problem, because separate legal personality is a key principle in company law. So therefore, only in very limited situations this would be allowed. Hence, courts will not lift the veil of incorporation without extreme necessity. Only in situations where there is an extreme necessity to lift the corporate veil, that the corporate veil will be lifted. Right. So this was also said in a particular case, not very important, but if you can remember at least a part of the name would be good. Can write down Littlewoods Mail Order Stores Limited. Littlewoods Mail Order Stores Limited versus Inland Revenue Commissioners. Inland Revenue Commissioners. Inland Revenue Commissioners. Right? Let's see what happened in that case. The appellant company, Littlewoods Mail Order Stores, carried on business as chain stores, as a chain of stores, right? So it was a chain of stores, not one store alone. Littlewoods obtained a lease through Folk Manufacturing Corporation Limited, a wholly owned subsidiary of the company. So Littlewoods got a lease through Folk Manufacturing Corporation Limited, which is also a wholly owned subsidiary of the company. The deal was designed to allow Littlewoods to deduct the full rent from the profits and to evade tax. So basically, the lease was paid to reduce the profit, right? Agreement was that the profits will be reduced in furtherance of the lease and thereby to evade paying the taxes, because when your profit is being reduced, you pay less tax now because of that. At the end of the lease, Littlewoods would get the entire freehold by paying extra rent every month. So after the rent period or after the lease period, Littlewoods will get the entire freehold by paying extra rent every month. Littlewoods company attempted to pass off a capital purchase as a running cost. The Inland Revenue claimed that in reality, Littlewoods was acquiring the freehold whilst having it assessed as tax deductible, because rent was tax deductible as a running expense, whereas the purchase of an intangible asset was not. Now, at the end of the rent period, they were getting the property anyway. So that is purchase of a tangible asset. So purchase of a tangible asset is not tax deductible, but when they are paying it as a tax, that is when they are paying it as a rent, that is tax deductible. That is the trick that they use. Paid it as a rent so that it is tax deductible, but apparently they are getting the tangible property for them. The court determined that the company, which is a wholly owned subsidiary of Littlewoods, was not a separate and independent entity, and the extra rent was paid only to enable Littlewoods to acquire the freehold. Therefore, the rent was not deductible. So the argument was that anyway they are getting the property as a separate legal personality, therefore that the rent that they were reducing from the income tax, that cannot be deducted, that it is non-deductible. The doctrine laid down in Solomon versus Solomon Corporation Limited has to be watched very carefully. It has often been supposed to cast a veil over the personality of a limited liability company through which the courts cannot say. But that is not true. The courts can and often do draw aside the veil. They can and often do pull off the mask. So you can't say that, as I told you before, that this is untouchable. The corporate veil is untouchable. That is wrong, right? Corporate veil is, sometimes courts itself say that you have to pierce the corporate veil and find the culprits. They look to see what really lies behind. I think that we should look at the Folk Manufacturing Corporation Limited and see it as it really is, the wholly owned subsidiary of Littlewoods. At the end of the day, it's two subsidiary companies under the same owners. It is the creature, the puppet of Littlewoods. In point of fact, and it should be so regarded in point of law. The basic fact here is that Littlewoods, through their wholly owned subsidiary, have acquired a capital asset, the freehold of Jubilee House, and they have acquired it by paying an extra almost 19,006 pounds a year. Littlewoods are not entitled to deduct this extra 19,006 pounds in computing their profits, because basically it was among themselves itself. Though there was a lease, though there was a rental payment, all of that was amidst themselves itself, right? Why? At the end of the day, when you lift the corporate veil and see, owners are the same of both Fork Manufacturing Corporation as well as Littlewoods Mail Order Stores Limited. It's the same company. Right. So therefore, in that case, now the takeaway, you don't have to know the case facts of this case, not very important. Earlier three cases, what I told you, Solomon versus Solomon, Lee versus Lee-Zia Farming, and Mokora versus Northern Assurance, you need to remember the case facts. This case, you don't have to remember the facts, just a case to show that in particular situations, in unavoidable situations, court will pierce or look through the corporate veil to the owners or shareholders of a company. So let's see what are the situations where courts will decide to lift the corporate veil. The following situations are examples where courts have been known to lift the veil of incorporation. Number one, let's write down. When the company has been used, when the company has been used when the company has been used as a cover for deliberate wrongdoing. Company has been used as a cover for deliberate wrongdoing. There's a case law example. Let's write down. After that, I will explain. Guildford Motor Corporation Limited. Guildford Motor Corporation Limited versus Horn. Guildford Motor Corporation Limited versus Horn. So where the company has been used as a cover for deliberate wrongdoing. Someone is, doing a deliberate wrongdoing and hiding behind the corporate veil in a company. Let's see how it was shown in Guildford Motor Corporation case. Mr. Horn was a former managing director of Guildford Motor Home Corporation Limited. He was the managing director. His employment contract prevented him from attempting to solicit Guildford's customers in the event that Horn left Guildford's employment. Now, usually even in your employment contracts, this clause might be there that once you leave the employment, you can't solicit the customers of your employer. So same thing was there in Mr. Horn's employment contract as well. Horn was fired and he subsequently set up a competing company which undercut Guildford's prices. So he was sacked from the job. He went and started a competing firm where he reduced the prices a little bit than the Guildford Motor Corporation. Guildford did not have any legal restraints upon Horn's company, only Horn himself, right? Now actually, Horn started a company. Now company is only soliciting Mr. Guildford's customers, right? Horn's company is only soliciting soliciting Guildford Motor Corporation's customers. Now Guildford Motor Corporation has a problem with Mr. Horn only, not Mr. Horn's company. But if what Mr. Horn did, is it fair or unfair? It is unfair. Now, for example, let's say other than working for Onlineàka, I move away and start a company called Dilani Private Limited, where I am doing, let's say, chartered classes, right? Now, why I open that is because I want to get away from Onlineàka, let's say, and solicit their customers. I am giving the package at a lower rate. Simple example, right? Now, I started Dilani Private Limited, then it's not my obligation, no, Dilani Private Limited's obligation. But is it fair or unfair? It is unfair. Why? Why did I incorporate the company in this situation? Why did Mr. Horn incorporate the company? To get away from their legal liability, which is an unreasonableness done towards Guildford Motor Corporation. So therefore, court said, no, Mr. Horn can't hide behind a company and hide the wrongful act that he did going against his employment contract or going in breach of his employment contract. Guilford commenced proceedings against Horn individually, claiming that Horn's company was an attempt to evade legal obligation, not soliciting customers. Here, company was set up to evade Horn's contractual obligations. The court pierced the corporate veil and ordered an injunction against Horn. So in that situation, Horn was hiding behind Horn's company, but courts lifted or went through the corporate veil to identify Horn, who was on the other side of the corporate veil. Courts can pierce the corporate veil if a company is simply a mere device to evade legal obligations. Though this is only in limited and discrete circumstances. I am quite satisfied that this company was formed as a device, a stratagem, in order to mask the effect carrying on a business of Mr. E.B. Horn. So Mr. Horn hid behind a company to evade his contractual obligations. In that situation, courts lifted the corporate veil, looked through the corporate veil to identify the wrongful act that Mr. Horn did. So that is one situation where corporate veil can be lifted when the company has been used as a cover for deliberate wrongdoing. Second one you can write down, when the number of members fall below the statutory minimum, when the number of members falls below the statutory minimum, right? When the number of members, now usually company ought to have a number of members, no, for public limited companies, private limited companies, these numbers we are going to discuss later. If that number is not satisfied and if you have members below that number, automatically courts will look through the corporate veil to identify the shareholders behind, because the company cannot be maintained in that way. Third point you can write down, if the controlling shareholder uses the company as his agent, if the controlling shareholder uses the company as his agent, or if the corporate body is abused for an unlawful or improper purpose. So sometimes what happens is, when there is a controlling shareholder, when there is a majority shareholder, this shareholder uses the company as his agent or exploits the company to do what he wants through the company, to do unlawful or improper activities. In that situation also, courts can't allow someone to do illegal, improper, we can't allow a company to be used for illegal or improper purposes. In that situation also, courts will lift the corporate veil to safeguard the company, to see who is hiding behind the company to do something illegal. Fourth point you can write down, to prevent a fraud. That's of course no. To prevent a fraud. If someone is doing a fraud, hiding behind a company, to prevent the fraud, courts will lift the veil of incorporation. There's a very famous case for that also. You can write down the case, Jones versus Lipman and another. Jones versus Lipman and another. So it says the defendant had contracted to sell his land. The defendant had entered into a contract to sell his land. He changed his mind and formed a company of which he was the owner and director, transferred the land to the company and refused to fulfill his contract. He entered into a contract with someone to sell the land. Now he didn't want to sell the land thereafter to that person. He incorporated a company and sold his own property to his company. right? Saying to the other person, no, this company took over the property. So they are trying to do a fraud. In that situation, courts will lift the corporate veil to see who is behind this newly incorporated company. The plaintiff sought relief. An order for specific performance was made against both the director and the company. The company could not escape from its divest itself of its knowledge gained through the director. The company was a creature of the controlling director, a device or a sham, a mask which holds before his face in an attempt to avoid recognition by the eye of equity. So to hide from courts only, he was using this particular power of the limited liability status of shareholders and the separate legal personality of the company. In those situations, courts will look through the corporate veil or pierce the corporate veil to identify who is behind the deliberate wrongdoings or who is behind the fraud, right? Fifth point you can write down. I'll erase these top parts. Otherwise, I will not have enough space to write down. Right. Number 5, you can write down. To determine a company's place of residence, for the application of specific statutes such as tax laws. Sometimes we need to identify the place of residence of the company. Why? Now, for example, Sri Lankan companies pay taxes to the Sri Lankan government. Then we have to identify whether the company is Sri Lankan or not. Then to identify whether the company is Sri Lankan or not, we have to identify the nationalities of the owners or the shareholders. For that, courts have to look through the corporate veil to see who are the shareholders, owners, directors, to see their nationality, thereby to incur a nationality on the company for the application of certain types of laws, right? Sixth point you can write down. To prevent deliberate evasion of contractual obligations. To prevent deliberate evasion of contractual obligations. So, like the case we discussed before, this Jones versus Lipman, also you had a contract to sell the property to someone else to evade that contractual liability. Even in the previous Guilford Motor case we discussed, to evade the employment contract. In those situations, if someone is trying to evade their contractual liability by hiding behind a company, courts will lift the corporate veil and say these are the owners and therefore they will be liable. You can't evade your contractual liabilities by hiding behind the pretext of a company. Next point you can write down. To promote the interests of national security, or to ensure conformity with public policy. Now, in some situations, you know, now even when you take what do you call it, now country, right? Countries have there are war-torn countries, there are problems between countries, and you must have heard of the principle that you don't do business with your enemies, right? You don't do business with your enemies. Now you would have come across this situation, now you would have heard about it sometimes when it comes to this India-Pakistan. Right? In those situations, usually you don't do business with them. Why? Because it's a little against public policy. I have come across situations where sometimes, you know, you don't even meet in places where, no, now let's say for example, if India is coming to Sri Lanka for a conference or something, if Pakistan knows that India is coming, they don't come. So like that. So even you don't do business with your enemy, right? So in that situation, let's say it's with regard to the public policy, it's with regard to public policy, national security. For those reasons, sometimes we will have to put a nationality, as we discussed before. We'll have to put a nationality on the companies for the national security, for public policy interests. In those situations also, court will look through the corporate veil to see who are the owners. Depending on them only, we will look at the national security and the public policy. For that purpose also, courts have to look through the corporate veil. And last but not the least, eighth one you can write down. Legislation sometimes lifts the veil. Legislation sometimes lifts the veil. Legislation sometimes lifts the veil in requiring holding and subsidiary companies to prepare group accounts. Now this was a little explained in that case we discussed about Littlewoods. In that case also, sometimes though they are separate legal entities, they have the same owner, same mother company and subsidiaries of the same mother company. So actually what will happen is, sometimes some of the subsidiaries are making big profits, some subsidiaries are not making that much profit, and thereby when it goes to the payment to the creditors, it becomes very unreasonable, because at the end of the day, all the profits are accrued to the same owners. So then the companies, the group of companies, have to settle all the debts as much as possible. For that purpose, group accounts have to be maintained. And for the making of group accounts, the corporate veil between subsidiary companies. So let's say this is the mother company and there's 3 subsidiaries. Now each of them will have a corporate veil around them. So this corporate veil will be lifted to identify all of these companies as one and the same owner. So all these corporate veils can be lifted to make group accounts of the company. The veil is lifted to determine if the holding company or subsidiary company really exists, right? So there is a case for this also, you can write down. DHN Food Distributors Limited, DHN. These cases are not very important. Food distributors, DHN Food Distributors Limited versus Tower Hamlets London Borough Council. Tower Hamlets London Borough Council. Tower Hamlets London Borough Council. Let's see what happened in this case. The veil would be pierced, stating that the group was virtually the same as a partnership, because when you take a group of companies, same owners, practically like a partnership in which all 3 companies are partners. This group is virtually the same as a partnership in which all the 3 companies are partners. They should not be treated separately. So usually in a group of companies, that all the companies should be treated as one and the same. For that purpose also, corporate veil can be lifted. So this lifting the corporate veil, identifying the corporate veil, identifying limited liability status of the shareholders, identifying the separate legal personality of the company and coming to the lifting of the corporate veil is a very important area, because they can even ask you scenario type questions based on what situations we will lift the corporate veil, how ethical it is to lift the corporate veil, what are the features that a company get because of the corporate veil, and things like that can be questions. So with that, the first unit we have completed, and I will meet you at the next lecture with the second unit. Thank you.